In this module I will introduce about patent. What is patent? Actually, a patent for an invention is the only territorial right representing and issuing corresponding country's patent office for the grant of an exclusive monopoly right to the inventor for the term of 20 years for new patent either process or product from the date on which the application for the patent was filed in that country, subject to the payment of maintenance fees in exchange with sufficient disclosure to the patent offices or public. A patent application must disclose a claimed invention in sufficient detail for the notional person skilled in the art to carry out the claimed invention. The patent owner may give permission to, or license, third parties to use the invention on mutually agreed terms. The owner may also sell the right to the invention to someone else, who will then become the new owner of the patent. Once a patent expires, the protection ends, and an invention enters the public domain. That is, anyone can commercially exploit the invention without infringing the patent. In modern usage, the term patent usually refers to the right granted to anyone who invents any novel, useful, and non-obvious process, machine, article of manufacture, or composition of matter. Some other types of intellectual property rights are also called patents in some jurisdictions. For example, there are 3 types of patents available in the United States, such as industrial design rights are called design patents, which issued for a new, original, ornamental design of useful objects. In general, this type of patent protects the appearance of an item. Ornamental designs of jewelry, furniture, beverage containers, eyeglasses and computer icons are examples of objects that are covered by design patents. Another type is plant breeders' rights, are sometimes called plant patents, are provided to anyone who has invented or discovered and asexually reproduced any distinct and new variety of plant, including cultivated sports, mutants, hybrids, and newly found seedlings, other than a tuber-propagated plant or a plant found in an uncultivated state. For example, lavender plant named Belper, cultivator of African violet, a variety of almond tree, a chrysanthemum plant named organdy. Finally, a new category is utility models, utility patent, issued for any process, machine, article of manufacture, or compositions of matters, or any new useful improvement. In short, it covers the functional aspects of products and processes. This type of patent protects the way an item is used or works. For example, heated air. A utility model is similar to a patent in that it provides a monopoly right for an invention. However, utility models are much cheaper to obtain. The requirements for grant of a utility model are usually less stringent and the term is shorter. Utility models are considered particularly suited for SMEs that make minor improvements to, and adaptations of, existing products. Utility models are primarily used for mechanical innovations. What are patents' rights? Once the inventor has been successfully awarded a patent in any particular country interested thereof, then they have the legal authority to exclude others from making, using, or selling, importing, distributing, the claimed invention in that country without their consent, for a fixed period of time. Thus, the patent owner has the right to decide who may, or may not, use the patented invention for the period in which the invention is protected. In this way, inventors can prevent third party from being benefited from their IP and ultimately, sharing in benefit from the invention, without their permission. In return for these ownership rights, the applicant must make public the complete details of the patented invention. These include: background information determines the general state of the art in the field of a given technical problem as background information for R&D activities, and in order to know what patent publications already exist in that field of the research activity. It also identifies alternative technologies which may replace known technologies, or to evaluate a specific technology which is being offered for license or considered for acquisition. Locate information about published patent documents involving specific companies or individuals, as applicants, assignees, patentees or inventors. Assist in determining the novelty, or lack of novelty, of an invention claimed in a patent application or a patent already granted, or even of an invention for which no application has yet been filed. The nature of any technical problems solved by the invention. In the context of the problem and solution approach, the technical problem means the aim and task of modifying or adapting the closest prior art to provide the technical effects that the invention provides over the closest prior art. The technical problem thus defined is often referred to as the objective technical problem. A detailed description of the invention and how it works, the description, together with the claims, is often referred to as the specification. These are the part of the patent application which specify particular claimed article or process and explain how it differs from previous patents and technology. The description starts with general background information and progresses to more and more detailed information about claimed article or process and its parts. Illustrations of the invention where appropriate. Patent application is required to contain drawings to understand the subject matter to be patented. The drawings must show every feature of the invention as specified in the claims. A drawing necessary to understand the invention cannot be introduced into an application after the filing date of the application because of the prohibition against new matter. Patent protection in a given country does not extend to other countries. Inventors must file an application in each territory where they want their patent to be effective. To maintain the validity of a patent, the owner needs to pay fees to each appropriate patent authority. Failure to do so causes the patent rights to lapse. Most countries also require that the patent is worked. This means that the protected invention is put to commercial use within a specified period of time. What does a patent do? Patent protects intellectual property lasts for 20 years from filing of the patent application, are functional only after issue, and only in the country where issued. Patents are costly and difficult to obtain. No one else can manufacture the product. A patent system should award private economic benefits to the inventors by support them with the right to exclude others from using their inventions. These economic benefits accruing to the investment for the inventive activities, society will benefit from the advancement of science and technology through the increased research and development investment in specific technologies that the society may need. Someone can pay you royalties by licensing. A license is an agreement that allows someone else to commercially use or develop your invention for a specified period. The owner of the invention is the licensor, and the person who is receiving the license is the licensee. You will receive payment in return that may be structured as a single-time payment or as continuing payments called royalties. Inventor can block competitors for infringement. Apart from economic and technological values, patents may create some strategic benefits for inventors exploiting positional advantage in market and technology spaces. The strategic value of patents include blocking or slowing down competitors' innovation capacities, reducing possible future litigation risks, using patents as bargaining chips in cross-licensing deals, gaining access to financial markets, and preventing key technologies from being invented around. Post 20 years, technology goes to public domain. Once a patent has expired or has been invalidated, it can be used by anyone without permission from the owner of the expired patent. The basic technologies underlying television and personal computers are good examples of valuable inventions that are no longer covered by enforced patents. Importance of patent. Patent documents are an important source of scientific information and act as repository of scientific inventions for R&D organizations and inventors, apparently most useful in the early stages of product development. During pre-development and in the invention stage, information can be gathered through browsing various databases like Derwent Innovations Index, United States Patent and Trademark Office, ASPAT Senate, and so on. Avoids duplication of inventions. By utilizing information available through various searches, so avoids wasteful duplication of efforts and the multiplication of costs that research aimed at finding solutions to technical problems. It acts as an inspiration or catalyst for further inventions, and this contributes to the advance of science and technology. Restrict competitors' violation of intellectual property rights, called infringement with respect to patents. In some instances where an inventor could not practice his invention even if he were to get a patent granted, because the idea, although patentable, would infringe competitor's patent. But obtaining the patent anyway may restrict that competitor to his ideas and prevent him from practicing ideas that were unforeseen by him. For example, let's say that company A has a patent on any form of a jar, and that company B surprisingly discovers any grip on the jar's lid allows people with weak hands to easily open the jar. If company B applies for and receives a patent on a jar with a gripped lid, they still would not be able to make its invention because company A has the right to exclude company B from making a jar. This does not mean, however, that company B should not apply for a patent on a jar with a gripped lid. If company B obtains a patent on the jar with a gripped lid, company A would then not be allowed to make a jar with a gripped lid. Company B now has a bargaining tool to negotiate a license with company A. Identifies emerging technologies and areas. Patent documents helps to track the rise of emerging technologies such as nanotechnology, biotechnology, etc., and can be used in conjunction with data on scientific publications. Business surveys, by contrast, usually come at a later stage of development, as they require precise advanced knowledge of the field, notably of the active entities. Particular technical fields can be built up by using keywords or by searching in abstracts and patent descriptions. The detailed information provided in patent documents also permits the identification of the companies or agencies active in these fields, the modes of invention, for example interinstitutional collaboration, and the mapping of technology clusters. What are the main reasons for patenting an invention? To get competitive edge, market power, and earning more money. Through these exclusive rights, inventor prevents others from commercially using patented invention, thereby reducing competition and establishing yourself in the market as the preeminent player. Licensing is a common way to earn money from a patent. When a patent owner licenses his idea to another, he grants permission the licensee to perform certain activities that the patent owner has rights to control, such as sell or make the patented invention. The license may be an exclusive license where the patent owner agrees to only license one party, or it may be non-exclusive where the patent owner makes no promise to not license anyone else to his patented technology. Add new revenue stream. To create new revenue streams for your business, there are some patent monetization strategies. Patent acquisition, acquiring the key patents needed to control a particular technology, gives your business plenty of opportunities for diversifying the income from your patent portfolio by building and marketing new products, licensing the technology to others, enforcing the patents. Patent licensing. Patent licensing is often more profitable than patent litigation because you incur less costs in both time spent and in legal fees. Patent sales. Selling of dragging patents due to high patent maintenance costs is possible monetization opportunities. Patent enforcement. If your patent is infringed upon by a major entity, it has the potential to yield damages and awards worth hundreds of millions of dollars. Before you consider a patent enforcement strategy, determine the following factors. Who are the infringing entities? What are the costs involved with enforcement and licensing? What is the time frame for those enforcement or licensing expenditures? What is the overall financial picture, that is return on investment over the time frame involved in patent licensing and enforcement? Raise funds and attract potential investors. Patents may attract potential investors to your company, as they are happy to see some type of barrier to entry for competitors, which may not only protect your investments in R&D and, thereby, improve the return on your investments, but also may provide income through licensing of your patents to others. Most venture capitalists, investment bankers, financial analysts, and other investors favorably recognize the value of a patent. Part of branding and marketing strategy. Not only employees, but also your product or even your whole business could use a patent or a portfolio of patents to signal higher technological capabilities, greater innovative abilities and superior performance in your advertising, marketing and branding strategies. Patents can be an important tool to protect the brand for any enterprises as a startup.